If you're a landlord in California, staying up to date and compliant with eviction process, laws, rules is super important to staying out of trouble, protecting your property, and protecting your wallet. In this video, I'm going to break down the latest eviction laws that have been passed that change the rules, common mistakes we see people make, and just give you everything you need to know to handle evictions properly and understand the process. So let's jump into it. I'm Steve Welty, CEO of Good Life Property Management, here to make owning rental property easy for you. If you get value from this video, please hit the like button and subscribe. Let's go. All right, so there's two big laws that went into effect in 2025 and they change and affect how evictions are handled. The first is AB 2347, and it basically extended or doubled the amount of time tenants have to respond to an unlawful detainer complaint, or basically an eviction. It used to be 5 court days or 5 business days, and now it's 10 business days. When I first heard about this, I was like, what the heck? It's already taking 4 to 6 months to evict a tenant. Now they need more time to respond. They said, well, you know, tenants need more time to kind of consider their options, look for attorneys. Okay. Great. The state actually did something cool in this one. They actually, to balance it out, also took away some of these loopholes tenants use in motions to strike, or it's also called demurs, a really weird word, demurs. So basically, without getting into the technical aspects of it, tenant attorneys were able to use these loopholes and just unnecessarily extend eviction timeframes. So I think overall, this law balanced out tenant rights and owner rights well. Ultimately, it should just be everyone's rights and doing things fairly, and I think they did a good job in this one. And if a tenant does file a motion to strike, the landlord now can present an oral argument, which is also supposed to speed up the process. So just some time frame changes to the law, a few technical changes that are important to stay up to date with. So AB 2347 extended the time frame that tenants can respond to a complaint, but it also lessened the time frame for a motion to strike, or demur. So basically, if a tenant files a challenge known as motion to strike, the court is required now to schedule a hearing within 5 to 7 business days, unless a later date is justified for good cause. This aims to close loopholes where things would get delayed because they're filing these motions to strike, these tenant attorneys, and so it helps cut down on frivolous like extensions and helps tighten that part of the process up. The next bill came from the Senate, and this was SB 611. SB was like a grab bag of a bunch of random things, but basically it prevents owners from charging a fee for paying with a regular check. Some owners want to like really drive people to ACH or Venmo or whatever they do, and so you can't charge extra for a personal check. Also, you can't charge fees for like serving a notice to vacate or serving a 3-day notice to pay rent or quit. And then randomly, they threw in this thing about protecting the military, which is great, that if you charge higher than 1 month's rent security deposit to a military member, then if they pay rent on time for 6 months, you have to refund that extra security deposit. All right, let me just give you a quick overview, step-by-step, of the eviction process in California. All right, first is serving the eviction notice. And there's usually 4 notices that people will serve. The first is a 3-day notice to pay rent or quit. This is the most common. Tenant didn't pay the rent. You've got to serve this notice before you do anything else. The next one is a 3-day notice to cure or quit. This is if there's like a lease violation, like you told them, you know, you can't work on your car in the driveway and spill oil, and they're a grease monkey, like working on their car, damaging your driveway. That would be a 3-day notice to cure or quit. Then there's the hardcore granddaddy of all notices, the 3-day unconditional notice to quit. This is really rare, but if your tenant did something just unforgivable where they're a threat to people or property, you can just give them a, hey, 3 days, you got to be out. I usually wouldn't recommend serving that. I would try a cash for keys situation or something first, or a negotiation, but that's a notice to know about. And then you got your good old 30 and 60-day notice to vacate. This is just when you're giving the tenant notice. Usually less than a year, 30-day notice is okay. If they've lived there over a year, you need to usually give them 60 days notice, but check with your local regulations because it can differ. All right, so you wait the 3 days. Is that business days? Is that court days? It basically is 3 days, but the 3rd day can't fall on a holiday or a weekend. Once that time's up, you're ready to file your unlawful detainer complaint. Please hire an attorney for this, because this is where it really rubber meets the road, and you got to have all your documents, all your I's dotted, T's crossed. After you file your unlawful detainer, you're going to have to hire a process server to serve the tenant with a complaint and summons. So the process server wants to try to serve them personally, so they're going to try to find them at work or at the property and just give them the notice. If they can't find the tenant to serve them personally, they can do substituted service. If there's an adult at the property, they can do that. If that doesn't work, they have to petition the court court and ask for approval to do what's called post and mail. Good old put the notice on the front door and then mail a copy to the tenant. Now you gotta wait for the tenant's response, and this is where AB 2347 comes into play. They had 5 business days prior, now they have 10 business days. So you're just waiting at this point. After that time period, you'll learn from the court if they've challenged your complaint or not. If they have challenged your complaint, you get your day in court. Congratulations. Both parties will show up. There's kind of this funny thing in the beginning where the court always gives a big speech to everyone there who's suing each other, saying, please consider mediation. We have a free mediator in this other room. It's right here. You won't lose your place in line. You literally have nothing to lose. It's free. You can settle it now. If you go to court and you lose, you can't many times appeal it. So it's final. Whereas if you go to mediation, you might be able to solve it. And it's like this very compelling argument that makes complete sense. And then it's hilarious because they'll be like, all right, so raise your hand if you'll mediate. And like 20% of the people raise their hand if that. Like nobody wants to mediate, apparently. Like everyone's gung-ho there to kind of get their day in court. So I just found that hilarious when I've seen that happen. So as a landlord, if you lose, well, it's back to the drawing board. You got to start the process over in many cases. If you win, you get a writ of possession. The writ of possession basically authorizes the sheriff to schedule the lockout and perform the lockout. Now, sheriff's lockouts are taking way long right now. So it's not this quick thing where the next week the sheriff goes to lockout. We're talking like could be another month, but the sheriff will notify the tenant that they're going to be by at a certain date and time to lock them out. And then they'll show up, you'll be there, hopefully bring your locksmith, change the locks once the tenant leaves, and now you got your property back. So here's a tip: when you go to court, have your supporting documents or your evidence really well organized. Like, you know how those really smart people in school would like have that perfect binder with all the tabs? That's who you want to be. You don't want to be unprepared or like pulling out things or asking them to look at the email on your phone. Make the judge's job very easy, and they're more likely to side on your behalf. One thing I didn't touch on about when you serve the notice to the tenant at the house. So your proof of service is super important, and you'll want to make sure you fill that out properly when anytime you give a tenant a 3-day notice or a 30-day notice to vacate or whatever it is. All right, here's some common pitfalls to avoid in the eviction process and to prevent you from even being here in the first place. The first is just really good tenant screening. So people often miss just very obvious signs of fraud. I've seen where people answer yes, they've been evicted before, and they just don't look closely. I've seen where people get duped, like they don't see obvious signs of fraud, like the license, address, date of birth doesn't match what's on the application, or the driver's license doesn't match any of the residences on the application. Some owners just don't do a background check. Some owners fall for like cash payments. They get excited, like, oh, I'll pay 3 months up front, I'll pay in cash or something. And then oftentimes people use that as a foot in the door. And then once they get in, they don't pay you the rest of the rent. Or they fall for urgency, like, oh, I'm gonna be, I came from this place to this place, my U-Haul's out front, I really need this place today, I'm willing to pay an extra $100 or something. Urgency is a bad sign. It usually means poor planning, and their problem is going to now become yours. If people can't make the full first month's rent and deposit up front, if they ask for you to split it up or pay, this now and this later, that can be a red flag, because that usually means they don't have the money and they're just one unforeseen situation away from not being able to pay the rent. The second big mistake people make is their notices are not correct. So when you go before a judge, first thing they're going to want to see is your 3-day notice, and it's got to be the correct amount. People often put late fees. They don't want to see you put late fees. People often put just one tenant instead of all the tenants. They want to see all the tenants. They want to see your proof of service, that it was filled out properly, that you either did substituted service, personal service, or post and mail. And the third big one we see is just people are too lenient. They come to us after the tenant's already 3 months behind, and maybe there was this hardship story that they felt compassion for, and so they let them go a month or two, and then they tried to catch back up, but they just couldn't. Accepting rent late every month can actually set a precedent where it'll be harder to evict a tenant. So if you're constantly accepting the rent late, it's a good idea to put in writing that, hey, this does not change our agreement, charging a late fee, and the rent is still due on the 1st, late on the 4th, or whatever it is. Like I said, please don't do the eviction yourself. Hire an attorney. They will make sure your notice is correct, and they'll walk you through the steps. It's usually around $1,500 to $2,500 to have an attorney handle all this for you, so please get counsel. I hope this guide to the 2025 eviction rules gave you the confidence to be a landlord and know how situations like this are handled. Make sure to check out our video on the new tenant screening law. Yep, so there's a cascade of new laws in 2025 I didn't even cover in this video. This is a nice pairing, like a fine wine going with a salmon. The new law video will pair very nicely with this eviction video. And if you have any questions or thoughts, please drop them in the comments. I respond to all of your comments, and I love answering questions. Stay informed, stay compliant, and I'll see you in the next video.